Ripple is under the gun with a newly filed motion by the SEC. What's next for XRP? A noteworthy development in the continuing legal battle between Ripple Labs Inc. and the Securities and Exchange Commission. The SEC has filed a motion with the Southern District of New York. The agency attempted to compel Ripple to produce financial records and information about its XRP sales on January 11. The SEC has specifically described the action as crucial for figuring out what remedies are suitable for what they think is warranted. Interestingly, the motion that was filed requests Ripple's 2022-23 financial statements. Additionally, ask for post-complaint agreements that specify institutional sales as defined by the SEC. The motion states that Judge Annalisa Torres previously concluded that these sales were securities sales and unregistered offerings. Even though it took part in the remedy-focused discovery process, Ripple has been adamantly against making post-complaint discovery papers public. Citing a court order, the CC disputes Ripple's justification for rejection. Amidst the ongoing legal struggle, the SEC has stunned many by filing a request requiring Ripple to reveal its financial records for 2022-2023. The motion further complicates the already complex issue between Ripple, a company well known for its legal wrangling, and the CK. Following the filing of the lawsuit, the SEC expressly requests information regarding the amount of proceeds from XRP institutional sales. The Securities and Exchange Commission's second Ripple's legal battle has taken an unexpected turn. The SEC has filed a motion seeking an order ordering Ripple to reveal its financial accounts for the years 2022-2023, which surprised a lot of people. This sudden request adds another level of intricacy to a case already replete with sophisticated legal wrangling. In a recent move, the SEC is attempting to force Ripple to reveal how much money it made from institutions for contracts that were signed prior to the complaint. The SEC charges Ripple of continuously accumulating large sums of money while marketing XRP as unregistered securities. The SEC claims that Ripple has made it clear that it intends to keep selling XRP to buyers in on-demand liquidity transactions who are institutional sales buyers. In response, Ripple argues that it can arrange upcoming sales in a way that complies with federal securities rules, refuting the regulator's assertion that an injunction is required. Ripple has submitted a motion for extension of time, asking for an extra 2 days until January 19 to prepare its answer in response to the SEC's demands. This action suggests that a resolution to the 3-year legal drama is still far off. The unexpected request for financial documents from the SEC suggests that the legal dispute between Ripple and the SEC may get more. The trial drama is being closely observed by the cryptocurrency world, with potential repercussions for the regulatory environment surrounding digital assets. The U.S. Securities and Exchange Commission has sought Ripple Labs' financial accounts for 2022 and 2023. To comply with the request, the corporation has requested an extension. Following the July 2023 court order, the SEC also requested the contracts that Ripple used to sell XRP to institutional investors. Then, Judge Annalisa Torres declared that institutional investors' purchases of XRP from Ripple constituted unregistered securities off. Financial statements are what the SEC wants to stop XRP sales. The agency said that Ripple continued to sell XRP to institutional investors in contravention of the judge's July decision. According to the SEC, Ripple misrepresented in its July report that the judge's decision did not affect the transactions the company carried out with foreign clients. Thus, its demands for institutional arrangements made after rulings, according to the SEC, Torres will be able to make decisions on whether and how much civil penalties to impose on Ripple Labs with the use of these materials. Future infractions may be discouraged by the documentation. It is essential to customize a penalty to prevent future violations by taking into account Ripple's existing financial situation and the real total amount it received from its violative institutional sales. To push back its filing deadline to January 19, 2024, Ripple Labs submitted a motion for extension of time. The business has not yet made a public statement on the matter. Ripple refutes claims of an XRP market dump. The inquiries from the SEC come as the business disputes reports that it sold XRP in bulk in December. Ripple allegedly sold 327 million XRP in a single month, about 3 times their average amount, according to a researcher going by the X name. Such assertions were denied by David Schwartz, CTO of Ripple, who stated that the sales numbers would be disclosed in the business's next market report. Even in situations where that transparency has been used against us, We have always tried to be transparent about our holdings. Regarding the SEC's request for Ripple's financial statements, or in general, what other comments do you have? Kindly send us an email or take part in the conversation in our comment section. In the midst of the ongoing legal struggle between Ripple Labs and the United States Securities and Exchange Commission over the non-security status of XRP, Bill Morgan, a well-known attorney who advocates for XRP, has provided his perspective on the lawsuit. No longer is there a conflict over the non-security status of XRP. On Thursday, January 11, Morgan expressed his opinion over the legal fight that is taking place between the two companies by posting a message on the social media platform X, which was formerly known as Twitter. As stated in the post, the attorney who is in favor of XRP has announced that the conflict between Ripple and the SEC about the non-security classification of XRP has been resolved. The X post was a reaction to the commission's most recent motion in the continuing lawsuit. A Rippleverse, that's the AI. All quiet on the battlefront, legal expert explains why the X post came about. Morgan claims that now that the fight is ended, the battle for post-complaint OD sales since December 2020 has just begun. This is because the war has been over. Morgan post on X was accompanied with a screenshot of a part that was included in the most recent file that the SEC had made. At an earlier stage of the action, the agency had attempted to file an interlocutory appeal, and it was mentioned that the agency had detailed its attempt. Earlier reports indicated that the regulatory watchdog had submitted a new motion the day before yesterday. In order to comply with the movie, Ripple is required to hand over two important documents and respond to an interrogation. Ripple's audited financial statement for the period of 2022 to 2023, as well as the company's post-complaint contract that controls its institutional sales of XRP, are the subjects of the documents that the SEC is requesting. In addition, the attorneys for the Securities and Exchange Commission, SEC, indicated in their most recent motion that they were requesting permission to initiate an interlocutory appeal in order to oppose the ruling made by Judge Analisa Torres that certain transactions and offerings of digital assets made by Ripple did not constitute securities, after Judge Torres had clearly determined that Ripple's programmatic sales and other XRP disbursements were not in violation of the law. This comes as a result of his decision. In addition, she came to the realization that, contrary to what the commission had stated, the token is not a security in and of itself. To this point, Morgan has emphasized that the members of the community may be subjected to a fierce legal battle during the period of remedies. Ripple Labs has objected to all of the demands for documents and interrogatories that have been made by the Securities and Exchange Commission. The time limit for the complete discovery phase in the beginning, the agency's most recent reports focused mostly on sales of the token to institutional investors. This is the first official motion that Ripple and the SEC have made in relation to the part of the case that deals with remedies. More information may be found at the following link.